you have competition outside.
Indeed. In the event that the owner or person in charge of the land or building fails to comply with the notice, in other words, fails to institute those proceedings within the period laid down by the MEC.
Now, not clear to me what that means. I mean, is there supposed to be notice in terms of particular property? Is notice administrative action, and therefore can it be challenged? What are the circumstances in which the minister may or may not issue the notice, and so on and so on? And those are complex questions which link the section 16 analysis to the threat of rights and the abstract nature of the challenge. The trouble is that in the abstract you don't know, unless you can enlighten us.
Justice Yaqub, I'm afraid I can't. The MEC would, by way of subordinate legislation, determine a period that would apply generally through the province or within each municipality within the province. And he would say the period for purposes of Section 16 is 3 months or whatever it might be. That is the way in which we understood it. There is no suggestion in the Act that the MEC would apply her mind to individual properties.
Unless there's a notice which you have in front of you, is it really possible to consider this section in the abstract?
Well, what one is able to do is to look at the consequences of its implementation. A proper exercise of the discretion we would submit would have to be an exercise compliant with the negative right to housing.
Would it be enough if the municipality is satisfied, genuinely satisfied, that Section 6 of PI has been fulfilled? Obviously, ultimately, the court will decide.
Your judgment in Olivia Road, for instance, makes it quite clear that there are a range of requirements for eviction proceedings, which, although not expressly stated in PI, are implicit in it when one reads it with the Constitution.
If one says that the owner or the municipality must be satisfied in relation to all those factors before, firstly, is it possible to interpret Section 16 in this way?
We would submit that Section 16 is unconstitutional because it precludes consideration of that kind. It also precludes meaningful engagement, which, as we understand your judgment in Olivia Road, is required before eviction proceedings are...
Is it reasonably possible to interpret Section 16 in a way which renders it constitutional, or would you say it's not? You'd say it's straining the meaning too much?
We would submit that it is not open to that interpretation, but may I defer that issue? I'm for the moment simply addressing the significance of the discretion which does exist under PI. I will turn shortly to the implications of its absence. In other words, to the implications of compulsion under Section 16.
Municipality has given a notice under Section 14 to the owner to remove the cause of the concern, say, for instance, a health hazard or a safety hazard, and the owner doesn't do that. Will the municipality not be entitled to take appropriate steps?
Section 26(2) requires as a peremptory constitutional requirement that there be meaningful engagement between municipality and evictee. The most important of these rights for present purposes is the right to human dignity and the right to life. A municipality that ejects people from their homes without first meaningfully engaging with them acts in a manner that is broadly at odds with the spirit and purpose of the constitutional obligation. 16.1.
What purpose does the coercion that sits in 16.1 pursue?
Well, it seems to us to be a reflection of a policy decision that no unlawful occupation should be tolerated. And therefore, that the owners, both the owners, it would be a double layer of obligation to ensure that all unlawful occupiers are evicted.
There are circumstances in which unlawful occupation should not be tolerated. You can't ignore the ministerial notice and what it means in determining the meaning of Section 16.
It doesn't suggest that the MEC can decide whether those duties should be performed or not. It says the owner has a duty. It says the municipality has a duty. The only role of the MEC is to determine, if I may quote, the period within which those duties must be discharged.
It seems to me to reduce it to the question whether, on its face, is this provision unconstitutional? And as I understand your position, it is that on its face, it is unconstitutional.
It does not allow this discretion, which we would submit as a constitutional imperative, which renders it unconstitutional. Residents living in informal settlements are often dependent on fragile networks to ensure their livelihoods and survival. A guiding principle in the upgrading of these communities is the minimization of disruption and the preservation of community cohesion. There is obviously a better and more appropriate solution to the problem, upgrading, for instance, so that we would submit that the two statutory provisions, the slums section 16 on the one hand and PI on the other, can't stand together. The same goes for the National Housing Act, and particularly Chapter 13. It says in different words much the same thing as PI, and that is, don't evict other than as a last resort and only in these circumstances. The Slums Act says you must evict whether these circumstances are present or not. In that sense, the two are also incompatible with one another.
What PI does, it provides a defense, but it does not purport to confer land tenure.
I'm simply making the submission that it confers some tenure protection on unlawful occupiers. They are threatened in the manner that Section 16 will impact on them if it is implemented.
That in the province, there are some, and there is some quarrel about the exact figure, but it's around the measure of 210,000 households, or there were some 2 years ago, who live in what, according to international standards, would be regarded as slum conditions, by which we mean degraded and degrading conditions for human beings to live in.
But it's my home. It's simple, but it's my home.
To eliminate slums, to prevent the re-emergence of slums, to promote cooperation between departments, municipalities, and at the end of the objects, right at the end, F, to improve the living conditions.
To survive court scrutiny, the MEC will have to be showing that he is put in a position where there is this irredeemably bad area which constitutes, or building or buildings, which constitute slums.
There are thousands of people who do live in squalid conditions. It's the poor who are the vulnerable people and who become victims of unscrupulous landlords and owners of properties.